Red Door Shield. Secure everything.
A law firm got a message, not a ransom demand to unlock their files, something worse. The message said, "We have copies of your client files, the privileged ones, the sensitive ones. Pay us or we publish them." Sit with that for a second. Not "we locked your data, we have your client's secrets and we will make them public." That is the moment a managing partner realizes a breach at a law firm is not the same as a breach anywhere else. Because the firm's most valuable asset, confidentiality, had just been turned into a weapon pointed back at them. If you practice law or you run a firm, this video is for you. I am going to walk through what makes law firms uniquely targeted and an ethical obligation you are already bound by that most attorneys have never connected to their own network. My name is Tony Chan. I founded Red Door Technologies, and in 17 years, I have protected a lot of small businesses, including law firms. So here's the core truth about cybersecurity for a law practice. For most businesses, a breach is theft. Someone takes data and sells it. That is bad. For a law firm, a breach is leverage. The information itself is the prize because of how sensitive it is and who it belongs to. That changes everything about how you are attacked and what it costs you. Let me show you the 3 reasons law firms sit so high on the target list, and then the obligation that should move this to the top of your priorities this week. Reason 1, what you hold. Think about what you store in your case files. Privileged communications, litigation strategy, settlement terms that are not public, mergers and acquisitions before they are announced, intellectual property, the most private personal matters in your clients' lives. A criminal does not even have to sell that on the open market. They can do something more direct and more profitable. They can point it back at you. Threaten to publish a client's privileged files. Threaten to leak a settlement before it closes. Tip off the other side in a litigation. Expose an acquisition early. The value is not just in selling the data. It is in the damage they can threaten with it. That is why I say it is leverage. With a law firm, the criminal is not just a thief. They become an extortionist, and your duty of confidentiality is the pressure point. Reason 2 is really 2 threats that ride together: money and access. First, the money. Law firms move significant funds, settlements, real estate closings, client trust accounts, escrow. That makes you a prime target for wire fraud. A criminal gets into a firm's email, watches a deal or a settlement come together, and at the right moment sends new wire instructions that look completely legitimate. The funds move to a criminal account. With trust account money, that is not just a loss. That is a client's money and a bar problem on top of the theft. Second, access. You represent larger clients. You have their documents, sometimes access to their systems. A criminal who gets into your firm can use your trusted relationship as a bridge into a much bigger organization. To them, your firm is the unlocked side door into your most important client. And reason 3 is the one that turns this from a security topic into a professional responsibility issue. Because protecting client data is not optional for an attorney. It is already your ethical duty. Most lawyers know Rule 1.6, the duty of confidentiality, but many have not connected it to their network. Rule 1.6 now includes an affirmative duty to make reasonable efforts to prevent the unauthorized disclosure of or access to client information. That is not just about what you say at a cocktail party. That is about your email, your files, and your firm's security. And there is more. The duty of competence, Rule 1.1, now includes technological competence in most of the country. As of today, more than 40 states, including Illinois, have formally adopted the duty for attorneys to understand the benefits and risks of the technology they use. Here's the part that should get your attention. The word in the rule is reasonable, and reasonable evolves. The Illinois Bar's own malpractice guidance has said plainly that what counted as reasonable security 5 years ago may not meet today's standard. So the question is not just, could we get hacked? It is, if we got hacked tomorrow, could we honestly say we made reasonable efforts to prevent it? Because after a breach, that is exactly the question the bar, your clients, and a malpractice carrier will ask. So picture what one breach actually costs a law firm. The client confidences exposed or held hostage, the settlement or trust funds possibly gone, the duty to notify affected clients, and in many cases the bar, the malpractice exposure, and the reputation. And reputation is the deepest cut because your entire practice runs on a single promise that what a client tells you stays protected. When that breaks, it does not just cost you that client, it follows you in a profession built entirely on trust and discretion. That is why law firms are prime targets. Data that doubles as a weapon, money in motion, a bridge to bigger clients, and a profession where a breach is also an ethics problem. Here is the good news. Reasonable efforts are achievable and provable. You can put your firm in a position where, if anyone ever asks, the answer is yes. We took this seriously, and here is what we have in place. That is exactly what our free business security assessment gives a law firm. We look at whether client data is genuinely protected, whether your email and trust account workflows are guarded against wire fraud, and whether your firm could credibly demonstrate the reasonable efforts your ethical duties now require. You walk away knowing where your firm stands, with criminals, with clients, and with the rules you practice under. No jargon, no pressure, just a straight answer from someone who understands what is actually inside your firm that matters. The link is in the description. And subscribe, because I am going through industries that are a target in this series. Next up, contractors and construction, and why firms in the trades are quietly losing six figures to wire fraud. But if you run a law firm, here is the honest takeaway. You are already bound to make reasonable efforts. The only real question is whether you can prove you have. The smartest move is to find out before someone else forces the question.
Stop hoping. Start knowing.